Hello, everyone. My name is Justin Muscolino, CEO of the FinTech Training Center. Today, we are going to dive into California's upcoming law on the Digital Financial Assets Law, or DFAL, which is going into effect on July 1. Now, this law is probably one of the most significant state level regs since New York's BIT license. And it's really going to change how crypto companies operate, manage risks, and maintain compliance in California. So, to help us break it down today, we have two of the best experts that will bring you both the legal perspective and the operational side. Shan Potts is our attorney who advises companies on regulatory compliance, licensing, and any legal implications in the digital asset space. And we have Joe Ciccolo, a leading expert in crypto AML, BSA compliance, risk management. Joe works directly with exchanges, fintechs, and FIs that, need to deal with these requirements. So we're going to unpack what DFAL actually requires, who it impacts, and really what companies should be doing right now to prepare for July 1st. So let's kick things off. Shan, I'm going to pick on you first.
Sure.
So you ready? All
I'm
right.
ready.
So from a legal perspective, what is the core purpose of the reg? And really, what problem is California trying to solve with this new framework?
Sure. I kind of like to approach this. Let me answer your question directly. I
Hmm?
think California sees a void in the market and is trying to create regulations that protects Californians. That's at the heart of it. It's consumer protection. And so it's trying to take an industry and bring it under to some some compliance that is easily understood, and that can hold companies accountable to Californians. That's at its core. That's the purpose at its core.
Joe, I got to pick on you because I know you're jumping out of your seat to add more.
Yeah, no, I agree with Shan. I think first and foremost, this is about protecting consumers, and rightfully so. California saw the need to protect consumers. A little bit of a jaded history. We've tried to create regulation going back to 2015, believe it or not, in California, and there was some legislative and policy missteps along the way. But fast forward to today, we have this tremendous opportunity, and with DFAL, it's we're going to talk mostly about the licensing portion, but there's actually two pieces of legislation that came together to form DFAL. One half of that, which we'll talk mostly about, is AB 39, which is the overarching licensing and regulatory requirements. And then SB 401, which isn't talked about as much, that's a specific bill that deals directly with kiosk operators. And that has already gone live back in 2024, believe it or not. So DFAL has some different moving parts, but for those that are looking at the larger structure, again, it's those two bills, but we'll probably concentrating our reflections on AB 39 and in particular the licensing requirement that, as you mentioned, Justin, is going live July 1st, whether we're ready or not.
Yeah. So cool. Good answers, guys. Now a follow-up, Joe. Now, we've talked prior. You spent a lot of time in conversations with DFPI leadership and, industry stakeholders. So can you give us some like inside baseball, like what are the nuances, common misconceptions, and so on?
Sure, yeah. So I've had a tremendous opportunity over the past several years to be part of the legislation into the rulemaking, and now, as we both mentioned, going live real soon here on July 1st. So definitely a front row seat and opportunity to engage both on the legislative side and now more so on the regulatory side of things with DFPI, Department of Financial Protection Innovation. And so we've had some tremendous conversations. They have been very forthcoming, very outgoing. They've posted a lot of community forums, different outreach opportunities, and then, of course, private conversations regarding more sensitive matters that are fact-based for different institutions. So we're pleased to see that. And in terms of the conversations, I'll speak, of course, generally and not to any specific member or client. Some of the reflections that we've heard regarding two main topics that I want to cover. One having to do with the surety bond. So the surety bond industry became a little frazzled and disappointed with some of the language that was initially put into the rulemaking. And it left a lot of different openings in terms of how things could be interpreted from a legal perspective. I'm not a lawyer, but I can recognize when some language needs some work from a lay perspective. And the surety bond industry, in particular the carriers, were unwilling to write policies, even for well-heeled and very safe, so to speak, licensees or prospective licensees that had a demonstrated history of compliance, had their financial house in order, so to speak, and even they were getting denied policies. And so the DFPI stepped back and said, okay, well, we're not going to get rid of these requirements, nor should we, but we're going to not tie your conditional approval to continue operating beyond July 1st to having this particular surety bond in place. So again, they're not getting rid of the surety bond requirement. That's first and foremost. They're not tying it to having a completed application by July 1st. And that reminds me of something, completed application. Let's talk about that. So there's a little bit of misperception in some quarters of the industry, particularly the smaller players, where they think, well, I can continue operating. All I have to do is get my application in before July 1st. Well, no, you can't slide under the door on the night of June 30th, right? Your application has to be substantially completed. It has to be accepted. In other words, that first phase where DFPI says, okay, send us your application. And as we both know, and I'm sure Shannon's experienced this too, there's a back and forth and, you know, some clarifications and some information that needs to be put into the correct field, or perhaps it wasn't stapled properly or something, you know, administrative like that, ultimately to get to that second phase where it's actually juried in terms of your acceptance. And so what folks have to keep in mind is please don't wait till the last minute. You have to submit your application. There's going to be a back and forth. It's not necessarily a reflection of you or your team, but rather that there are some things that get lost in translation, or some items we may not be clear about, or mean different things to different people. And so getting out ahead of that is super important. And then one final item I'll add real quick, and I'd love for Shan to share any input on any of these items as well. So coin due diligence or token due diligence is a big piece of this. In fact, there is a officer self-attestation that due diligence was conducted on any and all of the tokens and coins that are offered, listed, or supported on a particular prospective licensee's platform. And again, that's signed by the officer of the company that these various different due diligence steps were performed. And so there are a lot of concerns there by industry. From our conversations with DFPI, they've made it clear that they're not asking for a special new California framework. They're saying if you have a strong token due diligence policy that you're actively documenting and reviewing these before you list them, you're probably in a pretty good position already. So there was a little unnecessary concern about that, but that's good. I love people that are into compliance and want to double check things and are maybe, you know, questioning, hey, am I doing enough? So there's some good energy on that. And one thing to keep in mind with coin due diligence, and I'll close on this note, it is there are only two fines listed in the statute in AB 39. One of them is for unlicensed money transmission, which I think we all understand that's going to be there. The only other fine that is listed in statute is for the failure of submitting an attestation of due diligence on coin due diligence and token due diligence. So to me, that says how important it is to the legislature, and that translates to how important it's going to be for regulators. So I would highlight that as a point of emphasis for sure.
Justin, I wanted to add how I came into this space. I
Yeah.
came into this space as I was talking to particularly cross-border companies and individuals who are in this space, either founders or operators who happen to have other issues such as immigration issues. At heart, for the last 25 years, I've been an immigration attorney, and now I'm consulting with regulated companies concerning how these regulations and violations of regulations can escalate to other risks, sanctions by the state, civil matters, and criminal matters. I'm seeing this a lot. I advise criminal defense attorneys when companies kind of go afoul, and there's a narrative by the DA that it's not just a violation of a regulation, but it rises to the level of a charge against them. And importantly, with this particular regulation, it deals with the fiduciary duty that these companies have with Californians. It raises an important issue that I'm seeing prosecuted a lot with the Department of Homeland Security, and that is whether or not these are going to be interpreted or narrated by that body as crime involving moral turpitude, um, issues affecting the continuity of companies, their key players who, if they may happen to be non-citizens, the impact on this. And so I'm looking at it more than just compliance with that, but I'm looking at it from the downstream implications and how these facts can be interpreted, and how companies want to keep that continuity and what they need to. It's so important that the narrative is proper, that the due diligence is proper, because more entities are looking at this than California. And it's you want to get it right now so it doesn't have downstream implications. And that's how I came into the space. And as this regulation became apparent to me, I started to contemplate how this is going to impact a lot of the players in this space.
Right.
I think a lot of times we're thinking about it just in our operations, but we're not thinking about the downstream consequences to the members of our teams. And so that's what I wanted to highlight here.
Yeah, that's a good point. And that kind of leads me to my next question, which I was really curious about. So, Shan, like if you're advising companies right now, founders, startups, whatever, like what are you telling them now and how to prepare for July 1st? Because it's a few weeks away if they haven't done something already.
Well, one is to make sure that they are clear that death applies to them, that it applies to them, that they're not exempt. And I would use as a caveat, assume that it applies to you, and then make sure that you're going through to make sure that everything is in line. On that point,
Mhm.
I would look at whether or not, the due diligence is in place, whether or not we know which operators are governing which functions and so forth. And that there is a good compliance record, that all this is documented in a workflow. And so we know what responsibility is attributed to what players, and that the record supports compliance. So not just completing the filing, but that your record supports complying even after the filing. There's going to be inspections, there's going to be investigations. And so you want to make sure that you have like a solid record, a solid workflow, and a solid governance
Mhm.
with built into your operations to make sure you're in compliant and to protect your company and protect your members and ultimately protect consumers.
Mhm. So good answer. And that's going to lead me to my next question. Like Joe, I mean, there are parts of this that are pretty heavy lift for companies. So I'm curious, like, what are the heavy lift, medium, and I guess real quick wins they can go through on this?
Sure, it's hard to prioritize. Obviously, each potential licensee is coming from a different point of view, whether that's their product or service mix, or how long they've been in business, their customer base, et cetera. But if I think of it just sort of different buckets, the first bucket I think of is if you're relying on external parties, and by that I mean something like audited financials, right? You need someone who has experience doing that and is comfortable, by the way, working with crypto companies, and so
Mm,
that's a relatively small list. So that's something that is probably going to require heavy lift in terms of a financial commitment to that third party provider, but also the time in which they need to go through those particular financial documents to come away with audited financials that are prepared for delivery. Others, the surety bond, we talked about the considerations there. Again, it's not going away; it's merely being delayed, but that's still going to be a reality. And again, you're going to have to surround yourself with some prospective carriers, have those conversations, and ultimately be able to move forward there. As far as things that are maybe a little bit more within the realm of direct control by prospective licensees, first and foremost, look over your policies and procedures. Are everything up to date? Are you on time, on task, and have quality independent AML audits completed within the timely manner? Annual training, right? These are objective, easy to recognize data points that must be done within a prescribed period of time. Have you been able to do those? And are you in a position where your policies reflect the reality?
right.
We've talked to a lot of companies in the past that have great policies, and then it turns out they maybe aren't familiar with some elements of their policy, or are practicing in a different way. Maybe not out of negligence, but perhaps they've evolved and they're using something different. Well, their policies are reflecting something, excuse me, something completely different, and being able to demonstrate. And I think that was one of the big takeaways that we had in our conversations with DFPI They said, we've seen a lot of great policies, we've had a lot of great conversations, we've met a lot of talented compliance and legal folks. That's fantastic, and we're glad we're all on the same team. However, are you able to demonstrate that the items in your policy or the way that you've described your process is actually in effect in your institution? And in fact, the FPI has said, be prepared to expect something along the lines of a mini or a contracted exam, where they might ask, for example, for different samples, or they might ask you to navigate around a particular piece of software or solution you use to affect a compliance outcome, right? So being prepared for that, and it's difficult to prepare in the coming weeks we have, but recognize your strengths and weaknesses, where you are in terms of the document side, and then ultimately be prepared to effectively communicate and show and demonstrate and answer questions that begin with why. Why questions are some of the most difficult questions to answer generally. And so being prepared about that, anyone can show their process or show a document, but being able to back that up with the why and things that are data driven, but also things that are observational and experience led.
Yeah, when you mentioned Shan, please go ahead.
Yeah, I was gonna add to that. I picked up on using third party or outside auditors and compliance auditors, because that goes towards intent, and intent is often what's looked at. So it's not just your activities, but it's how your activities are going to be later framed and narrated. So having a third party auditor, making sure that you can demonstrate that you had the intent to comply is extremely important as well, to mitigate any sort of downstream risk. So ideally, we want to be in compliance, but if we're not in compliance, we also want to show that we had the intent to be in compliance. So this can't escalate and be framed by other authorities, prosecutor's office, or like I said, I focus on immigration a lot. So having all of that due diligence and that third party inspection is extremely important as well.
Now, thanks, guys. Now, I want to get a little granular with the licensing requirements. Joe, you brought it up a little while ago, and this is a big part of it. Now, Shan, with the licensing requirements, what should companies really prepare for? And, also, like even before that, who falls under this requirement in California?
I'll tackle the second one. I think Joe may be better position to tackle the first question, but I see it as anyone who's doing business where it serves Californians. So whether or not they're California operators or the cross-border operators, if your operation touches Californians and it deals with digital assets or crypto, then it applies to you. That's how I see it, being the most generous way to look at the regulation. So if your operation is affecting California, then you should assume that it applies to you, whether or not you're headquartered in California or some other jurisdiction.
Yeah, it kind of reminds me of the framework with CCPA, the privacy law, right? It has a lot of those remnants. Joe, I'm sorry, did you want to chime in?
I concur with Shan's opinion here that basically it's very limited exceptions. In fact, if you look at the statute, within the statute, the exemptions are few and far between, and ultimately relating to things that we sort of shrug our shoulders and said, do we really need to say travel rewards is exempt? So there's some there's some very limited exceptions there. In fact, there's a pending legislation in California, Senate Bill 97, that may iron out certain other exemptions. There have been discussions. Again, these are pending and these are open discussions, but at the moment, there have been discussions about in-game currencies and virtual land and all different things that maybe aren't in the spirit of what we might think of when we talk about digital financial assets. But to Shan's point, you best begin with the proposition that it does include your fact pattern, unless and until you receive some sort of regulatory determination specific to your fact pattern directly from DFPI. While the good news is the DFPI is very engaging and very cordial and professional and taking calls and conversations, they don't have a dedicated so-called no action decisioning desk or channel. Some states, Florida has done that in the past, and others as well, but California does not have that. So it's open to contact from prospective licensees and the public, of course, but there's no sort of formal channel for that. Ultimately, it's left up to their discretion to take those conversations and ultimately move forward with any sort of determination. So it is a bit dicey in that regard, but again, as I mentioned before, the DFPI has been super engaging with industry, and they want to hear if you feel like you have some sort of edge case. But I'll emphasize edge case and underline that. If you're an exchange, if you're some sort of platform that facilitates buy sell trade or anything like that, you're wasting your time with a phone call. I think it's pretty obvious, particularly if you've been licensed and registered in other states, that you're going to fall into that requirement with DFAL.
All right. So, Joe, a follow-up to this. This is one of the other requirements of DFAL. It's the risk assessments and monitoring. What does like a DFAL-ready risk assessment look to you in practice?
Sure. Well, we're going to find out real soon, but
Yeah.
based on our conversations and what we've seen and observing, they're very much into the demonstration portion and seeing that outcomes can be tied to actual events and actual goings on. So if you think about a risk assessment, you're assessing the inherent risks. What are the inherent risks associated with my customer base, product service mix, operations, geography, those sorts of different risk categories. What are my inherent risks absent any controls? And then thoughtfully aligning those inherent risks to your controls. Are the controls tailored? Do they make sense? Or are they just some sort of static reference to a particular control? Or more so, are they more meaningfully tied to that specific risk? So you can show the regulators, hey, look, we have these inherent risks. We all understand that they're out there. There's risks in everything we do, but here's how we're aligning our mitigating controls thoughtfully to those, and then backing that up with data. Data is
Yeah.
great, especially if you have a company that's been around for quite some time. They're probably going to expect that there's going to be an element of data-driven analysis behind that. And
Mhm.
we're not taking away from the powers of observation from talented compliance and legal folks, but I think that there has to be that data component, particularly if you're a more established player. But again, it comes down to thoughtfully aligning your mitigating controls with your inherent risk, because at the end of the day, that's a risk-based approach.
So, guys, this has been great. I mean, listen, we have a couple more weeks until July 1st hits. Probably going to hear a lot in the news leading up to it. So, I want to thank you guys for coming aboard and explaining it in detail. But I do want to give you the opportunity of any closing thoughts that you want to convey to people out there. Shan, I'll hit you up first.
Uh, it's not a lot of time until we hit July 1st. And so this conversation, I hope that many have been thinking about this ahead of time. But now that we're here, it's just to understand the seriousness of California's position and how I had an opportunity to speak with the California commissioner when I was at San Francisco Tech Week about the oncoming DAF regulations and how it will, I don't want to use the word aggressively, but assertively
Mm,
move to protect Californians and scrutinize these fintech companies, their compliance, and there will be investigations, there'll be follow-up. And so it's just a foresee that. So it's more than just a filing, it's more than just making sure you're followed by the regulations, but be able to protect your record afterwards. That would be my closing, in that don't just focus on filing by the deadline, but focus on afterwards being able to defend how you operate. And as Joe said, making sure that data supports
mm.
your compliance and supports that you're operating properly.
Joe?
Yeah, absolutely. Shan hit the nail on the head. Time is the enemy here. We're running short on time, and there's only so much that can be done for those that have either not started or are not as far along as they would like to be at this point. So we can't do anything about that, but we can do as much as we can possible to prepare. And as Shan reminded us, this is not about submitting information and application to just get a license, although that's the first piece. The other is being able to back that up and be able to have a supportable, sustainable company that can withstand the scrutiny of regulatory pressures and what the DFPI is going to throw at. California is very well known for protecting consumers, and aggressively so. I don't think aggressive is necessarily a bad word here, although I appreciate Shan wanting to to put some parameters around his language, I think here it's a positive thing when we're talking about protecting consumers, because at the end of the day, as Deputy Commissioner Lear reminds us, you're in a position of trust. If you're interacting with other people's money, whether you're directly custodying that or facilitating a transaction, you're in a position of trust, and there are a lot of expectations. And a lot of that can be taken directly out of AB 39, taken directly from the application and the multitude of different resources DFPI has put on their website, up to and including a detailed checklist. And I was scrolling through that, and I was continuing to scroll through that, and was pleasantly surprised by how voluminous and detailed it was. So the information is out there, the outreach is available. Surround yourself with good people, good teams, good processes. Do your research, and please, if you have not done so already, start turning up the volume and getting yourself in a position to submit a substantially complete application that will allow you to continue to operate and progress to that next step of engagement with regulators.
So I decided not to use the word aggressive because I didn't want to sound alarmist. But maybe I should, but maybe I should be a little bit more indirect, because I see that at the other end, all too fortunate when these things escalated. But you're right, you hit on the nail that California is known to be known to protect its constituents, its consumers. And so understanding that, you have to take this serious and have to make sure that your record is in place.
Absolutely. And just one more little extra on that, if I could, Justin. If you look at AB 39, and we talked about some of the monetary fines, I believe it's $100,000 per day for unlicensed uh, uh, money transmission, digital asset money transmission under DFAL, and $20,000 for the certification or fine associated with certification for digital asset due diligence. So these are substantial fines, and the reason I mention them, not just because they're in the statute, but if you look to past history with DFPI and how aggressively they went after the kiosk operators, and it's tempting to say that that's kind of its own unique subculture within crypto, and I would agree with that. But at the end of the day, the regulators used the statute of $2,500 per dollar per violation, and did the multiplication based on number of transactions and units, and that's why we saw a lot of prescribed or proposed, excuse me, $500 million with a B fines to kiosk operators. You're like, these guys don't have, $10,000 or two sticks to rub together. They have 20 machines. Why are they getting fined $500 million? Well, in certain circumstances, they went into the statute and used the statute as that tool to bring that kiosk operator to account and have that conversation, and then ultimately move forward with whichever disposition it was in particular case. But all that to say, the statute is there, they have the authority, and they have proven to be aggressive in the past. Again, kiosk operators are different, but what's not different is that there are prescribed fines in the statute, and a lot of discretion has been handed to the DFPI from the legislature through this legislation as well.
I'd like to add something. Sometimes when we're looking at the behaviors of operators, I can point out exposure risk, regulatory exposure risk, civil, criminal, immigration exposure risk, and not as often as I would like, you get the necessary responsiveness, but perhaps being aware that these substantial fines can take place and could in your operation, let alone what I'm putting forward, like these other risks. Hopefully that's something that operators will pay attention to, and that these fines are substantial, can put you out of business, and hopefully that gets the attention of operators to move forward in a responsible way.
Absolutely.
Gentlemen, this has been pretty educational and real. I really appreciate both of you attending today. I'm pretty sure we're going to need a follow-up at some point post July 1st to talk about lessons learned, other questions that arise, and so on. So hopefully you guys could join me again when we do our next session. For those out there, if you need any assistance, we have the experts here who know the law like the back of their hand. Please feel free to reach out. And I just want to thank you all for attending and have a great day.
Thank you, Justin.
Thank you.
Thank you.